Now, coming to the issue of those that Nnamdi Kanu wants to subpoena to give evidence. As I said earlier, this matter is sub judice. But let me make some general comments. I will refer people to Section 308 of the Nigerian Constitution. But in a nutshell, by virtue of that Section 3, there are people you cannot compel to give evidence in court. You cannot compel a serving governor to give evidence in court. That is the law. There is no sentiment there. Section 308, issue of immunity, it is there. You cannot, again, if you even take a look at the provisions of the Evidence Act, the relevant provisions, issue of compellability, even public officers, some public officers, like this issue of involving his extraordinary rendition, our law is that they are protected from being summoned to court to give evidence, to divulge information as to what transpired. That is the law. So it wasn't as if maybe this law was cast because Nnamdi Kanu was arrested. No. The law is that you cannot compel a public servant to come and give evidence that will give information, that will relay information as to that the official business of that public servant, especially when it concerns matters of national security.
But 7 ministers are not immune. They can't be subpoenaed.
7 ministers?
Yes.
They can.
They can.
They can, because they don't enjoy constitutional immunity.
Immunity, okay.
They can. So, having said that, however, there is an exception to this rule. But that exception, to a great extent, is dependent on the discretion of the trial judge. If the trial judge, in the interest of justice, believes that maybe there is need to subpoena some of these public office holders, not being those who enjoy constitutional immunity, that one is a no-go area. There's no exception to that particular rule. Then the serving judge can make an order, for such persons to be brought to court. But the evidence will be given in camera or in chambers. It will not be made public.
Okay, another confusing part of this is because a lot of people have questioned the relevance of some of these people to this case. Right, what is the relevance of a Governor Sanwo-Olu or Nyesom Wike to this matter and all of that? So, other than the fact that some of the names that he mentioned are 7 governors, some of them are former governors, some of them are 7 ministers and all that, but some are also questioning how relevant they are to the matter on ground. So, are you saying that it is also at the discretion of the judge to know if these people that he is requesting to be summoned to the court are relevant to the matter? And I mean, he can decide to or not to summon them.
Now, let me put it this way. In criminal adjudication, yes, the right to fair hearing, you have the right even to subpoena witnesses because he wants to have these witnesses subpoenaed. You have the right to subpoena witnesses in, establishing your innocence for a defendant. The same way the prosecution has the right to also subpoena witnesses, to prove the case against the defendant beyond reasonable doubt. And now, his rationale for trying to compel these persons to come to court is immaterial. To a great extent, is his right to subpoena them. Once bringing these people to court will, to a great extent, help establish his innocence. From commentaries I've read, I think he's trying to juxtapose, or better still, he's trying to establish that his actions were as a result of the actions and inactions of these other individuals. And that some official pronouncements and actions taken by some of these individuals, to a great extent, tends to exonerate him from the allegation, the criminal charges he's facing. So on the face of it, there's nothing wrong. That does not mean you start calling the whole world. But apart from that, the issue is this: there are some witnesses the law prohibits you from bringing to court. Secondly, some of these witnesses who are no longer public office holders or who no longer enjoy constitutional immunity, if these actions of theirs, which you are complaining about or which you believe they carried out, if these actions were carried out in their official capacity, you may also encounter another challenge because it wasn't done in their personal capacity. If it was an official act of the governor or of the person who you want to subpoena when he was a governor, to a great extent, he'll be protected. He cannot be compelled, to divulge that particular information. And I was saying something before
because he was a governor at the time the incident took place,
and that incident was done in the course of performing his official duties.
Okay.
And as I said earlier, the judge, in the interest of justice, ordered that some of these individuals should appear in court to make available some information that will help the defense. But in doing that, it won't even be made public. It will be done in chambers. That is the law. So it wasn't made today because issues of national security is under only a law like this recent law. Is no longer a new law, even the Freedom of Information Act. in this particular law I mentioned now, there are circumstances whereby in overriding public interest, the court can make an order if an application of that nature is made to divulge some what I would write as classified information. When the court takes a holistic look at the facts of the case, if the interest in divulging that information outweighs whatever other consideration. But ordinarily, if you are not trying to subpoena these individuals for them to give evidence as to what transpired, to help establish the fact that maybe they embarked on some lines of action which are detrimental to your interest as a person, you are to a great extent going to meet a very big setback as far as our law is concerned, or our laws, because both the Constitution is involved and the Evidence Act is involved. So, but by and large, the issue is this: the sensitive nature of this case, if you should ask me, requires the services of a lawyer. There are many lawyers, but trying to defend yourself, because the judge, even from what happened today, I think the judge no longer have that patience. The right to fair hearing is not absolute. I repeat, as I said earlier, what I'm discussing this evening, I'm just stating what the right to fair hearing is not absolute. That you are given the opportunity to defend yourself does not mean that you cannot hold the court at ransom.
Oh yeah.
You cannot do it. And that's why, like what played out today, an objection was raised against the jury, and the court said no, that you should open your defense.
Now this matter has been
because there's what we refer to as abuse of court process. If you start filing actions to the annoyance of whoever, it will be referred to as abuse of court process. Otherwise, a case will not be brought to an end. In other words, we can start going on appeal again, back and forth, go to Supreme Court, come back again, go back again, come back again. Because these issues, and if you take a look at the provisions of the Administration of Criminal Justice Act, good and fine, you may have some complaints about some interlocutory decisions made by a judge. The law is that in order to ensure speedy adjudication of cases, keep your gunpowder dry. Any complaint you may have against whatever transpired, maybe any interlocutory decision at the trial level, on appeal you can now raise those issues. But the cases should be determined one way or the other to its finality. But just like even when we lawyers operate, I'm sorry to say, but I have to say, because why I will say this is this. Why I make this comment is that at times when people discuss about delay in adjudication of cases, we tend to heap the blame on the judiciary. That judiciary, that people are in court, that people who are in custody, languishing without their cases being heard. Now, I am not the spokesman of the judiciary. The truth is this: whenever cases are delayed, many factors contribute to the delay in having cases entertained expeditiously. At times, it comes from the system. What do I mean? When you have fewer judges will not do magic. When you have about 10 or 15 judges handling thousands of cases, you want your cases to move very fast, but they will not do magic. They will only handle cases vis-a-vis their strength, and that's why they'll be giving longer adjournments. Now, coming to even we the lawyers, for the benefit of our clients, it's also unethical. Unethical in the sense that some lawyers intentionally, while working hand in glove with their clients, when they notice that their clients have a bad case, they may start embracing some dilatory tactics to waste time, to buy time, while hoping that maybe the prosecution will get tired, the witnesses may get tired. We've had instances whereby you find some defendants who are in custody. If they suspect that the material witness will come into court, they will fall sick in custody. They will miraculously fall sick. They will never get well until so that they will not come to court. These things happen, just like football match. Where if you are playing a football match, if you are winning your opponent, if it's 85th minute, if your team manager wants to substitute, you'll be clapping your hands, raising your hands, acknowledging cheers from supporters because you are winning. Your opponent will be angry, pushing you out and you should leave the pitch. So these things happen. What am I trying to say? Some of these tactics, many of us in the society, we are complicit, and that's where some judges are expected, or some judges do play a very vital role in being in control of their courts. Because at times when they discover that you are trying to waste time, they will say no. At times you find judges even given multiple dates. That this case should be determined one way or the other.
So we're coming back to what you said, because you said depending on if the consequence of your trial, I don't know how you said it. Some of this your terminology sometimes, but I think you were trying to say that if the outcome of now that he's facing terrorism charges and the repercussion is death or life
depending
in prison,
on the particular provision of that law, I wouldn't know there's that provision.
All right,
but I know that there is provision for life imprisonment and even death.
Death, all right. Then he must be represented by a lawyer.
Yes.
Okay, now that he's insisting that, he wants to defend himself, and the lawyer and the judge also availed him the opportunity, for the courts to offer him a lawyer, and he declined, and he stepped up to defend his case, and he went on ahead to say, oh, the court does not have the jurisdiction, and the judge told him that he's appealing to him to make use of the opportunity given to him to enter his defense or waive it if he wants. So if he insists that he wants to defend his case, there's nothing wrong with it.
Not at all. He will proceed.
And what if he keeps insisting that the court has no jurisdiction to try him? What is the judge expected to do at this point?
The court will also tell him, I'm giving you the opportunity to open your defense. If you insist that you have your way, I'm in control of my court. The court I'm assuming the court may say, even though I've told you to open your defense on Friday, being tomorrow, I may still give you more opportunity. That the issue of jurisdiction you are raising, I will not buy into it. Open your defense. If after a reasonable period of time he refuses to open his defense, the court will now say that the defendant is hereby foreclosed. The court will adjourn the matter for final address to be filed and for judgment to be delivered. In which case, on an appeal, you can now raise the issue that you aren't given the opportunity to argue your premier objection. The appellate court will now look at it vis-a-vis the entire face of the case and know whether the right to fair hearing was denied.
And if it wasn't denied, they will uphold the judgment of the lower court.
Subject to the other facts of the other facts of the case, other issues pertaining to that case, because you also look at the merit of the case itself, the case on its merit, because the prosecution has given evidence. So it's now, and from after the prosecution gave evidence, the defense team filed what we call no case submission. No case submission, saying that they had no case against the defendant, but the court now said no, that a prima facie case has been made out against you. It does not mean you are guilty, but there are some issues have been raised about you vis-a-vis this case against you. So we need some clarifications. You need to bring in more evidence to rebut. Maybe they may say that you did this. The evidence, the prosecution brought witnesses who say that you did this and so thing in connection to the charges brought against you. You are expected to say, yes, I did it based on so and so reasons, permissible under the law, or I didn't do it, or maybe I acted in self-defense. And I think that's the essence of trying to call on some persons to come and give evidence as to one of that in Jeremiah, one retired officer who once told Nigerians to protect themselves. It's a complex issue in law. I wouldn't want to delve it, because let me put it this way. Let me use our Niger Delta brothers as an example. Under the law, our brothers from the Niger Delta, during the militancy era, some of them resorted to arms. You will not come before a court of law, even though the matter was later settled politically. You will not come to court and say that why you took up arms against the state is because the state neglected you. The state will tell you that yes, you have the right to agitate, to protest against the government for the perceived injustice against your region, but that does not empower you to take up arms, because it's an offense against the state to take up arms. So having said that, you can also not come out to say that in law, we are discussing law now. You cannot come out and say that because Okafor told me that I have to protect myself, because of that I now decided to empower my children that they all should be armed. This is what the society ordinarily should take care of by, let's say, pushing for legislation that we now want to be like Americans, because the Nigerian government is not protecting the Nigerian people. Let all Nigerians now start bearing arms to protect themselves. But you cannot, on your own volition, now take it upon yourself to do what is against the law. The same way you cannot come out to say that you stole food item in the market because you are hungry, because that hunger is enough justification for stealing. If you steal the food item placed in that does not belong to you, you'll be made to face the charge of theft.